Orders, item 1.
May it please your lordships, in this matter, the learned amicus, Mr. Jordan Roming Thanga, has requested me to appear on his behalf because he is presently out of station. So if this matter may kindly come up again after 2 weeks.
Your Lordship, trial court record duly received, paper book has to be prepared, that's it.
This is an appeal from jail?
Yes,
Or what?
Your Lordship.
And what kind of appeal is this? Under what section? I mean, conviction?
302.
302. So, do we have to notify the respondent, complainant?
In 302, it's not,
Not
as far
required.
as my knowledge is concerned, it's not required.
But sometimes they make them a party also.
Yes.
I've noticed in the principal seat, they make them a party. And of course, unlike the other POCSO matters, we don't normally say that it has to be effective. So, let the paper book be prepared in the
Yes,
meantime,
Your
isn't it?
Yes.
Stop. On the other hand, Ms. Mary L. Kyangte, Learned Additional Public Prosecutor, submits that since the TCR has
Uh, 17/11/2025, we have preferred this instant revision petition. Lordship, however, at this stage, I found out that we have made some clerical error in the petition itself. So if I may be given some time to file an application for correction.
What sort of error?
Lordship, in page number 15,
15.
15, yes, of the petition. Point number C, the third line. Instead of writing dispose, Lordship, we have written dismiss. And in the next page also, page number 16, we have written dismiss.
Okay. Now, what kind of application is this? Under 227.
227, read with section 151 of CPC.
Why have you invoked both together?
Lordship, they've invoked these two sections because of Lordship, only revision petition, it may be a little bit wider, the jurisdiction of this High Court.
Under what?
227.
Under 227.
227, yes.
See, both the scope of 227, 115 are different.
Yes.
You'll have to address that issue.
I'll look into that also, Lordship.
You have to either go for one of them.
Yes.
Both of them are revision, no doubt. 227 would be some supervisory jurisdiction. 115 would be something else. Look into that. And
Yes.
another aspect is you're challenging this order
Yes,
of
Lordship.
17/11/2025.
1711, yes.
Why so?
Lordship, in this impugn order, Lordship, the lower court has disposed of the civil suit. However, the lower court has given direction in another, has given direction beyond the jurisdiction, Lordship.
Civil suit is still pending.
Civil suit is disposed of in this matter. And another same subject matter is pending.
See, come to paragraph 3 of the order.
Yes,
It's restraining you from selling the
yes,
disputed land, that's all.
yes. But however, this same subject matter it has been reopened as per the judgment and order passed by this honorable court. That is airship case, airship certificate application number 564 of 2002. This case has been reopened. And in my humble opinion, Lordship, that matter has to be decided in this airship certificate application, not in the civil suit itself.
Okay, we'll do one thing.
Yes.
Since you wanted some time to file an application for amendment, you do that. Mrs. H. Lalmal Swami, learned counsel for the petitioner, submits that there are certain clerical errors in the revision petition and for which she may be allowed to file an application for rectification of the same. Praise the Lord.
This-
The list again,
In the next week, Lordship. Yes. Deeply obliged.
Item 2.
Your Lordship, may I be kindly allowed to appear in person? May I be kindly allowed to appear in person, Your Lordship?
this appear in person, then I think there are certain procedures to appear in person.
My Lord.
Then you cannot appear as an advocate. You'll have to take off your ban.
All right,
This is
my
what
Lord.
is
If you
done.
permit, my Lord.
When any advocates appears in person in the court or either VC, or they have to take off their gown, they have to take off their band. You can wear your black coat, there's no problem.
Thank you, my Lord.
Yes, what is this case?
My Lord, it's regarding freezing of bank account, freezing of my bank account.
Okay. By which order?
The The order is just after the index, my lord.
Okay.
Senior Civil Judge Scholarship.
Yes, what is this order about?
This order is continuous staying of my bank account. Now, this order signifies that based on the order passed by Honorable Guwahati High Court in WPC number 9 of 2025, the matter may be kept in abeyance. Your Lordship may kindly see what order was passed by this Honorable Court.
Page
That
number?
is in
Page number?
yes, last page is, it starts from 137, my lord. Art, Mr. So-and-so, Land Counsel, who is also the petitioner in the case. The petitioner submits that the instant writ petition filed under Article 226 of the Constitution of India is assailing the order dated 3/3/2025 passed by Metropolitan Magistrate Saidapet, Chennai in criminal number 15 of 2025, wherein the order directed the respondent number 4 to defreeze and transfer the amount of rupees 27,90,009 from the account of the petitioner at HDFC Policy Branch, account number so-and-so, to the bank account of respondent number 5, without any legal justification or giving a notice to the instant petitioner. The petitioner submits that the impugned order was based on FIR filed by respondent number 5, who alleged that respondent number 5 had participated in a financial investment of a company or group named Aditya Birla Core Membership Group, which he later discovered was a scam operation, wherein he, respondent number 5, had deposited a huge amount of money to 18 numbers of different bank accounts, details of which are mentioned in FIR. The FIR was filed for the recovery of the money deposited by the respondent number 5 to the said different bank accounts. The petitioner submits that on the perusal of the FIR and the 18 numbers of bank account mentioned in the FIR,
Mr. Soirama,
my lord,
what have you challenged in that WP criminal?
in WPC criminal, the challenge was particularly to the order passed by Metropolitan Magistrate.
Dated 3/3/2025.
Correct, my lord.
What does the order say?
That the order was in page 121, my lord.
121.
Direction. As per the order passed by this court, dated 3/3/2025 in criminal MP number so-and-so, the investigating officer is hereby directed to issue necessary direction to the concerned bank to defreeze the below mentioned bank account number and to transfer the said amount, or if it is less than the same, the remaining available balance amount, to the account of the de facto Axis Bank account. This is the respondent number 5.
So
Serial number
this is an order for defreezing the account.
Decreasing the account plus transfer some amount from my bank account to the respondent number 5.
That is the Axis Bank.
Yes. Transfer to the Axis Bank from my HDFC account.
So
We are challenging this, my lord.
how are you affected by this order?
I was severely affected because I was never in connection with this person. I never know him. He never know me. There was nothing between me and him. How this direction has come up without giving me notice, without adding me as a party, without giving opportunity to me. That is why this order became arbitrary, my lord.
No. How are you involved in this thing? It says defreeze the bank account below. The bank
Yes.
account number below is belongs to whom?
Number one is my bank account, my lord.
Is it so?
My name was not mentioned, but my bank account was mentioned, my lord.
For defreezing.
Defreezing and taking out 27,90,000.
Meaning, and to transfer the said amount, or if it's less than the same, remaining to the account of the de facto Axis Bank.
Yes.
85.
Yes. De facto Axis Bank is the respondent number 5.
Respondent number 5. Just a minute. Respondent number 5.
B.K. Chandrasekharan.
Yes, who is he?
He is as per the record, he is some person doing business. He has done business at some investment, Aditya Birla, as per the record. And they have an agreement with the Aditya Birla.
Okay.
Based on the agreement, as stated in the FIR, 15 commission person had to pay to the investment group by this Chandrasekharan.
Okay,
So-
just a minute, Mr. Soirama. Your bank account number is this thing, ending 737, correct?
Correct, my lord, correct.
Then by this order, it says that your bank account is to be defreezed and the amount is to be transferred to the de facto, to the account of the respondent number 5.
Correct.
So, is it that you owe some money to respondent number 5?
Nothing at all, my lord. I have
Then-
never known this person.
Okay, so you don't owe any money. That is why you challenged by filing WP criminal.
Yes, my lord.
And in the WP criminal, what is the order passed?
That was in the last page, which we have just come across. Page number 137, my lord. The operations of this impugned order was state,
Operation of 3/3/2025 state, correct?
my lord. My lord.
Okay, that much we have understood. Now, why have you
Yes.
come with this revision?
Yes. Earlier, on January 2025, when I came to notice that my account was freeze, I approached the respondent number 1 and 2 bank authorities. But I was not given any formal information. So I served a legal notice, and then nothing was done. And then I approached the civil court for claiming damages. Now, in the meantime, they had filed written objection. So
Yes.
from the written objection, we came to aware that this respondent number 4, 3, 4, and 5 are involved in the case. So we impleaded as a party, and filing the damages suit, I also filed an injunction application.
Okay. So, CMA 14 of 25 is injunction.
Correct, my lord.
Filed by you.
My lord.
And not to release any amount lying in the applicant's bank account.
Yes.
Then state the operation of the so-and-so. You would be
During the
approached court
stay,
goes to your property
No.
to wait for the decision of the. So what is wrong in this order then?
my lord, here, the injunction first order that was staying the operations of my bank account in as a whole. That my account was wholly state, including the disputed or non-disputed. Now, that is okay at the first instances, my lord. But after the submissions of written objection by the parties, bank authorities, and this private respondent, there is no nexus with my bank account. The private respondent has also submitted his bank account and all the transactions which is available in this report. If my lord may kindly come to page.
Mr. Soirama, see, you have filed this revision petition against the order dated 28/1/26,
My lord.
correct? Order dated 28/1/26 merely states that pending final consideration of that WP criminal, court decides to await the
Correct, my
decision
lord.
of the High
Correct.
Court.
Correct, my lord. This pending of WP criminal cannot be the ground for staying my whole account, which was undisputed, my lord. There are disputed and undisputed portion, my lord. If all the undisputed amount of my income bank account is stayed, how can I live, my lord?
No, where has your account been stayed? Show me which part of this order. By which part of the order has your account been stayed? Show me.
Oh, this order 28/1/2026, my lord. Considering the this
See,
this is
your
the order
application has not been considered, saying that since there's a WP criminal waiting, pending, so let us wait for the outcome of the WP criminal, then we will consider your application for injunction under Order 39, Rule 1, 2, and 3. That is all. Beyond that, there's nothing.
Then the first stay order still exists, my lord. The first stay order is page 37 to 41.
Page
37 to 41.
37.
Relevant part will be in page 39, para 8. After the hearing the counsel of the applicant, it is seen that if the contentions of the applicant is correct and unexplained action regarding the account of the applicant without proper knowledge and justification would be prejudicial to the applicant and negate the purpose of the suit. Also, considering the said prayer for an ad interim as is of urgent nature, this court allows the ad interim prayer of the counsel for the applicants and directs the opposite party to maintain status quo and not to dispose any amount till hearing on the point of injunction or till any further order. Now, this injunction hearing was concluded on August 2025.
How was it concluded?
Hearing was done among the parties, my lord, regarding this injunction application. That was in paragraph number
In fact, this is your application, isn't it?
yes, paragraph 15, we have mentioned it,
CMA 14 of 25 is your application.
my lord.
Was praying for a direction not to release any amount from your bank account.
Yes,
So by the order passed on 5th of March 2025, court has given an interim, in the interim, court has directed the opposite party to maintain status quo
yes,
and not to dispose of any amount till hearing on the point of injunction.
yes,
So this order remains as on today?
yes, yes, my lord. Since there was no change to that.
So what is your grievance then?
My grievances was that my account cannot be used by me. The disputed amount was, whether rightly or wrongly, that will be heard at the appropriate time. But the undisputed amount, I cannot use it. It was freeze, my lord.
Freezed by which order?
That order, my lord.
Which order?
That senior civil judge order, my lord.
Huh?
That senior civil judge order, which we have just come across.
Which order? Which order dated? Order dated?
5/3/2025, page 37 to 41.
This is not a final order. Now, you have annexed another order passed on 28/1/2026.
and that remain enforced, my lord.
Okay, anyway,
Since no order was passed, that remain enforced.
so your account, no money can be deducted from your account, and even you, the account holder, cannot utilize the amount.
Correct.
That is why you are aggrieved.
Yes, my lord.
Okay.
As far as the disputed amount is concerned, it will be in respect of the final outcome of the
How
court's order.
much is the disputed amount?
The disputed amount as per the report is 27,90,009.
Okay. Now, who are the parties here? HDFC
HSC, yes.
and
Number 1 and 2, HDFC. Respondent number 3, 4, 5. Number 4 is the state of Karnataka, who is the employer of respondent number 4, case IO. And respondent number 5 is the person who filed FIR.
May it please, Your Lordship. Your
yes,
Lordship, in this matter, I am appearing for the respondent number 5, Your Lordship.
5.
Yes, Your Lordship.
Who's respondent number 5? Okay, DK
Respondent number
Chandrasekhar.
5 is DK Chandrasekhar, Your Lordship.
Okay.
Your Lordship, we have already filed an writ appeal with regard to the order that was passed by the single judge in WPC Criminal 9 of 2026. And my learned counsel was making his submission, the order has been stayed by the Chief Justice.
Writ appeal has been filed.
Yes, writ appeal has been filed. It was listed today as item number 1 in the division bench of Aizawl.
Today?
Aizawl bench, Your Lordship. And that order has been stayed, Your Lordship.
Writ appeal date number?
Writ appeal number 1 of 2026, Your Lordship.
1 of 2026.
Yes, Your
And
Lordship.
order dated is today.
Yes, Your Lordship. As the learned counsel was making his submission, in the other courtroom, the court proceedings were engaged,
Order
and
dated-
that order has been already stayed, Your Lordship.
18th
Notice.
February. So we'll issue notice and you accept
My
notice?
Lord, yes. Let me correct myself, my Lord. I'm just getting instruction, Your Lordship. My Lord, notices have been issued, Your Lordship, but Your Lordship, the counsel is here, Your Lordship. He may make the submission, Your Lordship.
May it please your Lordship.
Yes.
Lordship, in the division bench, right now this matter has been heard, Lordship.
Yes.
And the division bench was of the view that this order passed by the learned single judge, staying an order passed by a magistrate in Chennai is absolutely illegal. That's why, Lordship, they have given a short date on 5th March and they will dispose this matter off. And also, Lordship, notices were issued by Dusty Service and also by registered post, so that the matter can be heard and disposed of on 5th of March. And
Okay.
the Honorable the Chief Justice was also of the view that the order passed by the single judge was absolutely illegal and it cannot have been passed in a writ petition.
Okay, but is there any stay?
Lordship, the indication has been given that it will be set aside. The only reason why the stay was not granted was because of the fact that there is an injunction passed.
So there's no stay.
There is an ad interim injunction running against me, but there is no stay. So
There's
Lordship
no
may
stay.
fix this matter after 5th of March, Lordship. There is
So-
no stay, Lordship. Or it
so-
may be tagged together with that writ appeal, Lordship.
So today we issue notice in this case and tag it with that writ appeal, Mr. Soirema.
Yes, Lordship. Yes, Lordship.
Your Lordship, if I may allow, my Lord,
Yes.
that the writ appeal is in regard to the challenge of Metropolitan Magistrate Order. Now, the matter before your Lordship is regarding the injunction application which have stayed the whole of my account, undisputed and disputed account. As far as disputed account is concerned, it
Okay.
is in touch with criminal, WPC criminal, which was before the division bench, as just spoken by my learned friend. So how it will be connect with the writ appeal with this case, my lord. This is
The
a
lordship,
matter regarding to undisputed amount, my lord.
Okay.
no,
What would my
there
learned
is
friend
no
do with
undisputed
the
amount, lordship.
undisputed
All the
amount?
amounts are disputed. All the amounts are disputed, lordship.
No,
And what
your
I am
documents
suggesting,
are here.
lordship,
You cannot misguide the
now,
court, my friend.
now, lordship,
All
what
your
is
documents
happening,
are
lordship,
available in the record.
already the matter has been heard and no order has been passed by the learned magistrate in Kolasip. So, lordship may kindly, we have no copy of the
Revision
civil
petition.
revision petition file. So, lordship, what I am suggesting, lordship, a copy may be furnished to us and fix this case after 5th of March, and we will conduct the hearing, lordship. And whatever it is, we should have a copy, lordship. And on 5th of March, lordship, I'll file the order what has been passed by this division bench right now, lordship, in the division bench, lordship. Lord, it has been indicated this order is absolutely illegal.
All right. So we'll issue notice at this stage. And
Lordship.
whether it is to be clubbed together or not, let it be open
That lordship will let it
for
be
later
open.
on. As
Yes,
of now,
lordship.
we will not club it together.
Lordship.
Please write down Hart Mr. Lal Soirema, the petitioner in person, who submits that being aggrieved with the order dated 28/1/2026 passed by the Court of Civil Judge, Senior Division, Kolasip, in CMA number 14 of 2025, arising out of civil suit number 2 of 2025, the petitioner has filed the instant revision petition invoking Article 227 of the Constitution of India. Stop. The learned counsel submits that next para. The learned counsel submits that what is the subject matter of the civil suit, Mr. Soirema?
A claim for damages, suit for damages, my lord.
Okay. Learned counsel submits that. No, the petitioner in person submits that he had filed civil suit number 2 of 2025, claiming damages from the opposite party / respondents for what?
Lordship, the suit has been filed, lordship, claiming damages against the HDFC Bank for freezing the account. That is the case.
For having freezed his bank account.
Yes.
That is HDFC bank account number 50-100-611-946737. Stop that. In the said civil suit, the petitioner had filed an application under Order 39, Rule 1, 2, and 3, CPC 1908, praying for a direction not to release any amount lying in the account of the petitioner without any legal justification. Next para. It may be noticed herein that the Court of 11th Metropolitan Magistrate, Saidapet, Chennai, page 121,
Yes, correct.
Passed an order on 3/3/2025 in CR number 15 of 2025 in a case filed by the state represented by the Deputy Superintendent of Police, State Cybercrime Investigation Center. Directing the HDFC Bank to defreeze the bank account of the present petitioner and to transfer the amount in the bank account to the account of the de facto Axis Bank account. Whose account number is this? Ending 685?
It may be Chandrasekharan, my lord. Chandrasekharan, respondent number 5.
That is my account, Lordship. My account.
Respondent number 5.
To the account of the present respondent number 5. Stop. Aggrieved with the said order, the petitioner approached this court by filing WP Criminal number 9 of 2025. Challenging the order dated 3/3/25 passed by the 11th Metropolitan Magistrate, Saidapet, Chennai. In CR number 15 of 2025. And this court, by order dated 13/1/2026, while issuing notice to the respondents passed an interim order staying the operation of the impugned order dated 3/3/25.
Lordship, which is under challenge in the writ petition, writ appeal, Lordship. The said order is under challenge in the writ appeal, Lordship.
I understand that. Passed by the said Metropolitan Magistrate. Stop. The petitioner in person submits that while such is the position, the learned Court of Civil Judge, Senior Division, Colossi, by the impugned order dated 28/1/2026, decided to wait for the outcome of WP Criminal 9 of 2025. And that the order of status quo passed by the same court on 5/3/2025 not only prevents the HDFC Bank to make any deduction or transfer of the fund, but also prevents the petitioner from utilizing the deposit made in his own account. Stop. Hence, the instant revision petition seeking appropriate direction. Next para. Mr. Your good name?
P. Deca, Lordship.
Mr.
P. Deca.
P. Deca, learned counsel, at this stage also appears through RVC and submits that he has instructions to appear on behalf of respondent number 5. Stop. He also submits that aggrieved with the interim order passed by this court on 13/1/2026 in WP Criminal number 9 of 2025, the respondent number 5 filed writ appeal number 1 of 2026 before this court, and the same was taken up today, wherein court issued notice and fixed the next date as 5/3/2026. Stop. He submits that prima facie the appellate court was of the view that the interim order passed by the learned single judge was not maintainable. Next para. Be that as it may, considering the projection made in the instant revision petition, let notice be issued, returnable by 10th of March 2026. Mr. P. Deca, learned counsel, accepts notice on behalf of respondent number 5, petitioner in person to. How will you serve notice? By, can you send it by soft copy?
My junior is there in the bar, my lord.
Sorry?
My junior is there in the bar, my lord. He will serve it.
Serve it, Lordship. Yeah, I also have, Lordship.
Or through registered post, we can do that also.
No, it is easier if a copy has been served, because in the bar also one of my colleagues is there in the bar.
That's more convenient.
Okay.
Yeah.
Learned counsel for the the petition in person to serve notice to serve a copy of the civil revision petition to the learned counsel for respondent number 5 within 2 days. What about the others?
We will serve by registered post, my lord.
Okay. Petition in person to take steps for service of notice upon the respondent numbers 1 to 4 by speed post within
My lord.
5 days. Now, registered post has been changed to speed post.
My lord.
So, all the steps are to be taken by speed post
My lord.
within 5 days. List again on 10th of March. All right.
I am obliged, my lord.
I'll be obliged.
Orders, item 6.
My lord, as per yesterday, or
Yes, this is that matter, yesterday's matter.
yes, I'm bringing the ERDA response.
Yes, tell me, what is this letter?
It is in page 6, serial number 79. Lalchona name is reflected.
Page 6.
Serial number 79.
Lalchona.
Lalchona.
Then,
And the second last column is solicium. And the last column is the interest. It can be seen from page 2. We can compare from page 2.
last column is solicium.
Last column is interest, 12%.
Interest. Second last is solicium.
Yes, my lord.
Then the land value.
No land value, my lord. Only the cross value.
Crops.
Yes, my lord.
So how much is the total amount pending?
The total amount pending is 4,62,808.
4,62,808.
808, yes. Yes, my lord.
Now, insofar as the crops damage is concerned, that has been paid to you,
Yes, my lord.
but not the solicium and interest.
Yes, my lord.
And this lull Chona had expired
Yes, my lord.
during the pendency of the writ petition.
Yes, my lord. We are very sorry that we had not done substitution.
But nevertheless, the amount has been released to the legal heir.
Yes, my lord.
Now, as a legal heir, have you applied? Have you submitted application for release of this 4,62,000?
See, verbally I talked to the Kala and Kala said that beyond the judgment and order, we cannot go.
No. See, not judgment like that. We cannot modify the judgment like that. You see, you are asking for modification of judgment and then setting aside the abatement, whatnot. These are all too complicated, not required that. See, now, thing is that Lal Chona has expired.
Yes, my lord.
During the pendency of the writ petition, court was not informed. Court passed the order saying that you release the amount to
Yes,
him.
my lord.
But he expired.
Yes, my
Then
lord.
the wife came.
Yes, my lord.
Then the wife was, the amount was released to his wife
Yes, my lord.
by the Kala.
Yes, my lord.
But insofar as the solicium in interest is concerned, it was not released.
Yes, my lord.
And the reason, according to you, is that there was no separate order for that.
Yes, my lord.
Correct?
Yes, my lord.
And now you want a separate order for release of that amount. But the award itself speaks that this is meant for him only.
Yes, my lord.
Now, all that you have to say is that you are the legal heir of the Lal Chona and make an application to the Kala, and they should release that. And if he doesn't release, then you know what is to be done. Subject to what you have to say, I think that is what needs to be done. Because now we have filed so many applications, you see, which is not required. Condonation, amendment, substitution, setting aside. Now, how do we set aside the order in a sitting singly? Setting aside can be done only by the appellate court. And there's nothing to review also.
Yes, this, as per my research, this matter cannot go inside the review purview because of that I am filing the IA.
You can obtain heirship certificate. Like supposing the deceased person had an LSE. You can apply, I'm the legally wedded wife, I want a heirship certificate for the LSE. You are given. With that, you go to the revenue and they changed your LSE into your name. Similarly, you can say that he was given an award under this award number so and so. Principal amount for crop damage is already paid, but insofar as the remaining balance amount of the solicium interest, this is my entitlement. So with that, you can file an application to the Kala and that should be released to you. You have not approached the Kala till now, isn't it? By writing,
Ver-
by
writing, I haven't
by way of an
approached.
application.
No, by verbally, I went to the Kala office and talked to Kala, and Kala told me that we cannot go beyond the adjustment
No.
because of that.
See, if you are entitled to the principal amount, you are also entitled to the interest and solatium, whatever is there.
Yes, right, my lord.
It is not a separate award.
Yes, my.
It is one
yes,
and the
correct,
same
my lord.
award. It is a statutory entitlement. This cannot be deprived. But only thing you have to show that you are the legal heir. That's all. Now, where is your payment receipt? Do we have it
Yes.
for the principal amount of 9,49,000? When was it given to you?
In the application number, application number 10.
10.
Page, yes, my lord.
Page number?
Page 15.
Now, there is, Kala has changed. The person has changed.
Person has changed, yes, my lord.
Person has changed. You do that, see, what is your good name? Miss
Jacinta.
Jacinta. You write one application
Yes, my lord.
requesting for release of the amount, and you can enclose this order also, this order passed by the previous Kala, saying that the principal amount is already paid, the remaining balance amount, which is this much, as per the award, should be given to me. Write that application. And if you are not given that application, you are entitled to come back again before this court by filing a separate case.
Okay, my lord.
That will be easier. Now, you see, condoning delay and all that, because review also, and we cannot set aside the order, like out here you have invoked section 152. Section 152 CPC is only for correcting the mathematical error, clerical error like that. Even without your application, court also can do the correction, suo motu. But out here, it is not about the correction. Something was missing there, so it goes without saying that if you are given the principal amount, the remaining amount of interest, solatium should also go to you. It cannot go to anybody else. And you have already shown the order by which you have been given. Kala was satisfied that you are the heir. So accordingly, you submit an application. If your application are allowed, you come again to this court. We'll see what can be done.
Okay, my lord.
And
Then may
if you can enclose some documents in support of your claim that you are the wife of that deceased person and you are the legal heir, it will be more helpful.
may please be reflect that matter to approach the court by way of writ, something like that. No,
Not required.
Because in writ petition number 118,
In writ petition number,
in writ petition number 130 of 2023, 130 of 2023, the court advised me to go for review of this purpose.
where?
Verbally they advised me to to approach the court by way of review.
130.
130 order is in. 130 of 2023, page 12, 109 of 2023.
I have seen it. There's no mention about that.
It is mentioned, my lord. About
Page number?
Page 13,
13.
yes.
There's
Here,
only
I
notice.
had already approached the court, but there is some technical error. Because of that, I withdraw with liberty to Fairfax. Then after that, I file again WPC number 109 of 2023, and in this also, that is the big issue. And because of that, I withdraw the case.
No. Which case did you file? 109.
Earlier, 109 of 2023. Then after that, page 12 is WPC number 109 of 2023.
Oh, it's the same thing, 109 only.
And page 18 is the WPC number 130 of 2023.
130.
Yes, my lord.
130. What was your prayer in 130?
To release the solicium and interest arising from award number 1 of 2012 and interest on delay payment under section 34.
Then
And that is
you withdrew this again.
yes,
Why?
because that is the main issue, and because of that, they suggest me to file a review in this respect, and because of that, I withdraw the case and I oppose this court again.
Now, have you filed review?
No,
You have not filed review?
No, as per my research, this cannot go within the review purview. Because of that, I am filing IA.
So, again, you're back to square one. What is this 118 of 2000? Oh, this is the first case.
Yes, my lord.
118 of 2000.
Yes, my lord.
So, you attempted to file 2 writ petitions. Ultimately, you withdrew both. Then you have filed now the IA.
Yes, my lord.
IA for condonation, amendment, setting aside, substitution, all these things. I don't think it's required. You only say that you have not approached the Kala by way of an application.
Okay, my lord.
Only verbally you have approached. You file an application, enclose the documents, all these documents, the award, the earlier order of this court, and the, the order of the Kala by which you have been given that principal amount.
Okay, my
Approach.
lord.
And if that is denied, and not denied, that is denied to you, then you may come again before this court by filing a separate writ petition.
Okay, my lord.
We will see.
Okay, my lord.
I will not indicate anything because liberty is not required. It was always open for you to come before this court.
Okay, my lord.
There is no restriction. Only thing is that whether there is merit or not, that is to be examined. Okay.
Okay, my lord.
As prayed for by Ms. Jacinta
Zothanmoy.
Zautanmoy, learned counsel for the applicant, the IA stands disposed of on withdrawal. With liberty to approach this court again, as may be permissible in law, if the occasion arises. So this will go in all the IAs. There are 1, 2, 3, 4 IAs. You take back this award also. You will file one representation application for release of the amount
Yes,
by
my
enclosing all the necessary documents.
Yes, my lord.
And if you do not get the relief, you know what to do.
Okay, my lord.
Yes.
Item 7,
Much obliged.
Item 7. Yes.
My Lord, I'm appearing on behalf of my senior, Mr. Jesse.
Sorry?
Lansanga. I'm appearing on behalf of my senior, Mr. Jesse Lansanga. So, we
Please
have
speak loud. Why? You are nervous.
No, my Lord, I'm appearing on behalf of my senior, Mr. Jesse Lansanga.
JC?
Yes, the counsel for the appellant.
Yes,
So
then?
we have received their paper book in this matter, so the matter may be listed for hearing.
Okay.
Yes, we have received.
All right, please write. Parties are represented by the respective counsels and they submit that they have received the paper book. In view of above, registry to list the matter for hearing as per its own turn.
Right.
Item 8.
May I please, Your Lordship?
Yes.
My Lord, I have taken steps by way of dusty upon the sole respondent, and I had filed the affidavit indicating the service report upon the sole respondent.
Mr. Victor L. Ralte, learned counsel for the appellant, submits that he has served notice upon the sole respondent by way of dusty as permitted by this court, and he has filed an affidavit to that effect. Stop upon perusal of the affidavit, which appears to have been filed on 30/1/2026. Notice upon the respondent, sole respondent, is accepted to be complete. Respondent is also Victor.
Yes, my
Formalizing Thara. I hope you know the same person. Huh? Then we'll list it again. Since no one represents the sole respondent, let the matter be listed again. Do you want a date or after a week?
After a week,
Be listed again after a week to enable the respondent to appear or be represented.
my Lord, there's an IA, there's an interim order in the IA. This may continue. The proceeding of money suit
By which
has
order?
been stayed in the IA, my Lord, from the first order. It has been continued, extended time to time.
In the IA, right, in view of the order passed in the main appeal, let the matter be listed again after a week, along with the appeal. The interim order passed earlier shall continue till then,
Deeply obliged.
till the next date.
Deeply obliged.
Item 9.
My Lordship, I filed Wakalat Nama for respondent number 5 yesterday.
5.
Yes, my Lord.
What is this? RFA.
My Lord.
And the rest is government.
Respondent 1 to 4 with the government.
Has the appeal been admitted?
Yes, my Lord.
TCR is there?
Yes. And my Lord, paper book may be prepared for.
TCR
has arrived.
TCR has come.
Yes, my Lord.
Okay. Mr. Lomo Moralte, learned counsel, submits that he will be appearing on behalf of the respondent number 5, and that he has filed his power yesterday. Stop accordingly. Notice on respondent number 5 is complete. Stop since as the TCR has arrived, the registry shall prepare paper book expeditiously at the cost of the appellant, and thereafter list the matter for orders. After supplying a copy, after a copy of the paper book is furnished to the opposite party, to the rival parties. Okay.
Item 10.
If I may, Your Lordship, this
Yes.
is an application for grant of anticipatory bail in favor of the applicant, who has been charged under Section 308
Who has been
319.
charged?
Lordship,
Who has been charged? The petitioner.
the applicant as well as the other the other 5 co-accused. They have been charged under the same offense, 308, 319, 240, 61, and Section 3 of BNS.
Where is that?
It is at page...
It's at the stage of investigation, isn't it?
Yes, Your Lordship.
Page 18 is the FIR.
Yes, Your Lordship.
19 translation.
Initially, the separate application for registering of the NFI was filed by one James Zoliana, which is at page 27.
27.
Yes, Your Lordship. From then on, some investigation was conducted, and it was found that some false information had been given by the said James Zoliana. Thereafter, the case was taken up, and FIR was separately lodged on the said date, which is on 17/2, which is at page 18.
You have been named in the FIR?
Not personally, Your Lordship, but in the course of the investigation, we have been called to appear before the investigating agency, and we have also given our statement. Last year, before the case was registered, we had been summoned to the Kulikon police station. And due to that, we had applied for anticipatory bail without knowing the actual merits of the case. And that time we were granted interim protection. But during that time, we were called to provide our statements, and we had appeared before cooperated with the investigating agency, and we had appeared whenever called upon. And at this point, it was learned that there was some sort of extortion of money going on between James Zolian and some of the co-accused persons. Now, Your Lordship, our contention is that from the statement which was recorded, from our statement which was recorded by the case IO, it is seen that we were only present in the place of occurrence, since we were informed by one of the co-accused who had owed us some money, that she had some work and that she would be able to repay us the money which was owed to us if we had gone to the place with her. So our only involvement is in the instant case is the fact that we were there at the place of occurrence without knowing the circumstances and the facts of the reality of the instant case. Our statement is at page...
You had approached this court earlier?
Not this court. We had approached the district court.
And for anticipatory bail?
Yes, Your Lordship.
Was it granted?
No, Your Lordship.
Not granted?
Not granted.
Where is that order?
It is at page 54. And the operative part is at page
54.
62 onwards.
There are 3 petitioners. No, 4, 5.
There are 5 petitioners, but they were in 3 separate applications. The present petitioner had filed the bail application along with 2 other petitioners in the district court.
Where is that?
At page 54, Your Lordship.
No, her name is not there.
Number 2.
Okay. Anticipated bail application 70.
Yes,
number
Your
2.
Lordship.
Okay.
Since this has come up for the first time and it seems it's a sensitive case, if I may be granted some time to get instructions, Manoj. All right, Monday. Today's,
Yes, Friday is a holiday.
then my lord, Tuesday? Tuesday.
Your Lordship, we have made a prayer for interim protection if this court allows. Okay. Jonathan Lorin Tluanga. Anticipatory bail application. Your Lordship, in the meantime, I have mentioned that she is suffering from certain ailments. So if I may be allowed to file an additional affidavit regarding the medical documents.
Today's 18.
18. Obliged.
Obliged.
Admission item 3.
Your Lordship, 1 month have passed passed since I've taken steps upon respondent number 4, and I filed the affidavit for Dusty, but he's still not represented till today. Respondent number 4. Yes, my lord. Yes, my lord. And my lord, if notice be deemed complete, he is the driver of the accident vehicle. Yes, my lord. I'm not sure about the date, but we have served him on December last year. Yes, my lord. We have submitted the affidavit of Dusty on 16 January. on 11th December, my lord, 2025. Yes, my lord. Yes.
What is the ground for filing the appeal?
My lord, one of our main ground is that the claimant have failed to prove the income of the deceased. Yes, my lord. And we have also submitted the claimant have submitted a fabricated document, which is a cover note acknowledgement letter from the insurance company. Yes, my lord. My lord, the tribunal did not appreciate our submissions before. My lord, we have submitted on page number 15 of our grounds. Judgment. No, we have not annexed our WS, my lord. Yes, my lord.
How will you know that you are taking a stand about the documents being fabricated? What all have you filed? The evidence?
My lord, I think we can see that on page number F of the folio, the judgment. Yes, my lord. Paragraph number 5 of the judgment in award. Of the judgment in award.
Yes, Your Lordship, the paper book has not, we still not yet received for respondent number 1 and 2. The paper book. Yes.
Not yet, my lord.
Not yet.
I'm not sure, my lord.
Because you have annexed everything except for the WS.
Yes.
Evidences are here.
My lord, I think paper book will not be required. But it is up to your lordship. Yes,
Have you furnished a copy of this agreement to them?
Yes, my lord.
Do you have a copy?
Yes, my lord.
Have you received?
Yes, my lord.
Please write parties are requested by the respective parties, except correspondent number 4. Officer Rahul Rao is under counsel for the evidence of that notice has been served upon the respondent of the party of trustee. And respondent number 4 has really acknowledged the same on 11/12/2025. Stop. He also summons that the appellant has filed an affidavit incorporating the notice accepted by the respondent number 4. It's currently the notice of the respondent number 4 is accepted to be complete. Is the matter for admission after the
Yes, my lord.
the current counsel for the appellant shall
Yes, my lord. Okay. I'm obliged, my lord.
Item number 4.
My lord, the notice is deemed to be completed upon the sole respondent. Yes, my lord. Yes, my lord, RFA. Yes, my lord. My lord, this appeal is against the impugned judgment and order that the respondent already sold some portion of her land to the appellant, but no formal sale deed was executed. Belatedly, the respondent herein obstructed constructions of the building, leading her to file the said suit. The appellant also made a counterclaim against the respondent herein praying certain reliefs. Despite sufficient evidence in favor of the appellant herein, the case was decided in favor of the respondent herein, and the counterclaim was dismissed by the impugned judgment and order dated 11/12/2024, passed by the Civil Judge Senior Division 1, Aizawl District, Aizawl, Mizoram, in the Civil Suit 46/2020. Yes, my lord. My lord, in this appeal, TCR will be required and the paper book as well. In the meantime, my lord. Yes, my lord. Not yet, my lord. Talabana, my lord. Talabana. Yes, my lord. Yes, ma'am. My lord, we'll try Dusty. My lord, the respondent alleged that she borrowed rupees 1 lakh with a denial of sale of the land. However, it is not in dispute that the said rupees 1 lakh was used for completion of the construction of her own house. The evidence shows that give and take of rupees 1 lakh was in October 2005. Obliged, my lord.
Item 5.
Lordship, I'm appearing on behalf of my senior CGC for the sole respondents. Lordship, on the last date of hearing, CGC submitted that she would file an affidavit during the course of the day. We initially attempted to file an affidavit for respondent number 5 only. However, we later received instructions to file a joint affidavit for all the respondents. And the draft affidavit was sent to the Prasar Bharati Legal Cell, New Delhi for vetting. And the same has not yet been returned. If your lordship may be pleased to grant 2 weeks' time to file our affidavit. The sole respondents 1 to 5.
On the last occasion, CGC appeared for respondent number 2 only. Now, you say that she'll be appearing for all.
The sole respondents, my lord.
No, there are 5 respondents.
Yes, my lord.
Union of India, Ministry of Information and Broadcasting, then Director General, All India Radio, Pay and Accounts Officer. So affidavit will be filed by all of them?
Yes, my lord.
Joint affidavit?
Yes, my lord.
When can you file that?
I don't know, my lord. I cannot say the exact time. If I may be pleased to grant 2 weeks' time.
You had drafted the affidavit for whom?
For
You had-
5.
Huh? For 5?
5 only.
So now you'll be...
That is the director and head of office, Prasar Bharati All India Radio, Aizawl.
Affidavit was prepared for 5 only.
Yes, my lord.
But now you say that it will be prepared for everyone.
Yes, my lord.
How much time?
And we already sent for
How much
vetting.
time?
2 weeks, my lord.
You have already sent
Yes, my lord.
for vetting?
Yes, my lord.
I see.
My lord,
Yes.
if I may,
Yes.
on 13-1, last chance was given to them to file the affidavit.
Lordship,
So this should be the real last chance, my lord.
may I place my instruction, my lord?
Yes. So it doesn't indicate when it was sent and how much time it will take. And it also does not indicate that all of the respondents will file the affidavit. From where are you saying that not only 5 but all will file?
We received an instruction from DR Laropuya, director. Yes, and he mentioned that all the respondents 1 to 5 wants to file a joint affidavit. And the amended draft affidavit in opposition shall be sent to the Prasar Bharati Legal Cell, New Delhi for vetting.
Okay, we'll give you some more time. Although, as per the last court's orders, the respondent number 5 was supposed to file the counter affidavit, but today Ms.
Baby Laldin Zwali.
Baby Laldin Zwali, learned counsel, appearing on behalf of Zaram Sangpui.
Yes, my lord.
Appearing on behalf of Ms. Zaram Sangpui, learned CGC, submits that not only respondent number 5, but all the respondents will be filing a joint affidavit. She submits that the affidavit has already been sent for vetting, and therefore she requires at least 2 weeks' time to file the counter affidavit. In view of above, list the matter. After 2 weeks?
Yes, my lord.
All right.
Much obliged.
Any other matter?
No, hearing is for tomorrow. It's fixed for tomorrow.
Which hearing? Who is the counsel?
Yes, there's two items. Two items in the hearing list. Item number 1 and item number 11.
Just send me the file, 1 and 11. Okay.